Welcome back, everyone, to another session of Franchising with FASA. I'm Romany Threshen. Today we will be talking about copyrights, logos, trademarks, that topic. Do you have rights? What are your rights with the logos? What are your rights with copyright? Let's talk to Garth and find out. So Garth is an associate in the commercial law department. His experience includes drafting various commercial agreements, including franchise agreements, shareholder agreements, share sale agreements, pledge agreements, commercial leases, and documentations for mergers and acquisitions and MOIs. So Garth is with Fairbridges, Wertheim and Becker, and they offer commercial law advice in drafting of all franchise documents and commercial law advice, registration of trademarks and intellectual property law advice, labor law advice, litigation, electronic communications, and transactions advice. So hello, Garth, welcome to you.
Good morning, Romany. Good morning, viewers. I trust everyone's good.
Good. Just a hello again to everybody out there. If you have any questions or you want to know something you'd like to know about copyright, about trademarks, about logos, pop your questions into the comment box below. So let's get started and ask Garth all about copyright. So what is copyright and how does a logo qualify for copyright protection?
Okay, so copyright is protection provided to a certain closed list of works. Examples of this is literary works such as books, artistic works such as paintings, cinema films, which is the movies you watch, and the videos there too. So those types of works are eligible for copyright protection. Now, when we talk about logos, they would form within the category artistic works because they're works of art specifically. So a logo can receive copyright protection if there's enough skill, labor, and judgment attached to make it such as a work of art. So I just want to show you our logo, which you can also see on screen here. But okay. When you see it,
should have told me. I would have displayed it for you.
no, no problem. It's just a quick, indication, and I can see it at the box as well. So when a logo has enough artistic value, there's enough skill, labor, and judgment attached to it. It can fall under artistic work, and then by that reason, it can get copyright protection, which is automatic, by the way. So you don't register copyright; it's automatic. You just have to prove that you the owner or the author.
But now, is this who's the official owner? The artist who creates the logo, or the company that purchases the logo? Because what I often find is that when I ask companies for their logos, very few people seem to have a copy of their logo on file, and then they can't seem to find the designer who did it as well.
Yeah, it's a very interesting question because copyright, the first owner of copyright is the author or the creator thereof. So when you asking a graphic design company to design your logo, it's very important to have an agreement in place where they see that copyright to you, and you or your company becomes the owner thereof. It's very easy to forget, and then you have a situation where someone else owns your copyrighted logo and you were none the wiser. So it's when you ask outside people to design a logo for you, just make sure that there's fine print, that they sign over that rights to the copyrights to you, to your business.
Oh wow, I didn't know that. So you actually have to actually get it written on paper to say that you are the official owner of that logo as a company.
Yeah.
Okay, so word of caution to anyone listening out there: if you're a business owner and you're asking a graphic designer to design a logo for you, be sure that you have in place the authorization and the seeding of that copyright logo over to you. Otherwise, it could cause pandemonium later on, especially when we come into something called brand equity. So we've discussed that one. Who owns the copyright in a logo? All right, so what is a trademark and how can your logo qualify for trademark protection?
So trademarks are badge of origins that are used in the course of trade to distinguish your business's goods and services from those of a competitor. And I just want to give an example. You walk into a clothing store and you see a tick. Everybody immediately knows that that's Nike. you see three stripes or the trefoil logo, everybody immediately knows that that's Adidas. And that's the aim of trademarks, so that people can distinguish your goods and services from those of others. In the corner, you see the Fairbridges logo over there. When you see that logo, that trademark, that mark, you know that it's the oldest firm in Africa, and you know the type of service you get. So it's there to distinguish your goods and services from those of others and your competitors, so that they know this is the goods they're getting.
So you can actually also trademark a particular type of word, because I think I saw someone do that the other day recently. They do a specific type of yoga training, and they put a trademark on the yoga style, for example.
Yeah, words, logos, slogans can all be trademarked. It's important also to note that in the case of copyright, you can't copyright the word. Needs to have some artistic value, some skill, labor, and judgment. But names can be trademarked. Yeah, slogans, logo. And that's very important, so that people can know these are your goods, not those of your competitors, so that they don't attach that name to their goods and there's confusion in the market. So it's very important. So yes, names, logos, symbols can all be trademarked.
And how does it work with regards to people say, for example, I'm just the average Joe, and I'm busy just writing content, for example, and I use that term within my content. Is that allowed, or do I need permission for that?
Our content, now when you use any form of trademark in content, you need permission from the owner of that trademark as well. It's prevalent in franchising. You see various branches using the same mark, and that's because they have a license to use that mark. And that's why trademark registration is so important. You have something to license. You continue to make money with a simple name, a logo. When I see a McDonald's in Cape Town and I see a McDonald's in Bloemfontein, for example, that trademark, that name, that symbol is licensed. So you do need permission in the form of a license from the trademark owner.
But okay, I think I got that right. So if say, for example, I'm writing an article and I'm writing it, okay, I'm going to use this example because it's the African yoga teacher training, it was trademarked. So if I was writing an article as a third party or non-person out of it, but I want to talk about it, I must make sure that I get permission from the owner, or must I just be able to display that it's a trademark word, for example?
Now, if you're using it for write a review or something or article, it's fine just to note that it's a registered trademark, for example, it's not your mark. Then it's fine, because you're not using it in the course of trade. Yeah, which is important. Yeah.
I got you. Okay, so it's only really when you're in the trade motion.
Yeah.
Okay. So we did have a question. Okay, so how long does the protection which copyright provides last?
Okay, so when we're talking about the logo, if it qualifies as artistic work, then copyright lasts for 50 years after the death of the creator. So you made it.
Wow.
Yeah. So if you made it in 2010, but you only died in 2020, then copyright would last until 2070.
So if you don't have the rights to your logo, you could have it owned to someone else, and you can never possibly have ownership of it if it's still valid for 50 years after death. Wow. Okay. And can one receive possible to have a logo, to have both the copyright and trademark on a logo?
Yes, copyright is automatic. So if it qualifies as artistic work, then you would receive automatic protection, and then you're still allowed to go and register a trademark, which is strongly recommended. Yeah, so you can have a situation where a logo can have copyright protection and trademark protection. Should it qualify under both, and should you go and register the trademark? But yeah, trademark protection, highly recommended. And we'll touch a bit on that later on.
Yeah, I see so. And how long does the protection which a registered trademark provides last?
Mm.
Is that the same as the copyright?
No, it's very different. So trademark registration lasts for 10 years, but you can renew it, so you could have it forever, unlike copyright, which dies after a certain period of time. So 10 years, but you can renew it continuously, so you can have it forever. Your business can have it forever, passed down to your descendants. As long as they keep registering and paying those renewal fees, you could have it for life.
And what steps can one take when someone infringes your copyright or trademark?
Okay, so in both cases, infringement is the action. Um, so the copyright infringement, you see, starts off with approaching an attorney, writing a letter of demand, demanding a reasonable royalty, what you would have charged if that person had fairly paid the license fee for that, or if you can prove damages, a claim for damages. So you can sue for what you would have lost in that time. Starts with a letter of demand, they don't pay, proceeds to court. In the same way, trademark, um, you you can institute infringement action for damages and interdict to stop them from using that mark, and also for them to deliver up all the infringing copies. And you could also have the request to have them destroyed as well. So it's off the market so that people know that there's no association between that person and yourself. So there's good remedies available for trademark protection and good infringement steps that can be taken.
Is it quite an expensive process? Because I think a lot of people might be put off because of the cost factor related to, or maybe there's a perceived cost factor.
Yeah, it is quite expensive, so you need to weigh up whether it's worth it getting the trademark or not. There is another form of protection available, the common law right, but it's very difficult to prove passing off, which is the common law right. You need to prove substantial reputation, whereas in the case of a trademark, just show you a registration sheet and that gives you a right to sue. So it can be costly to register a trademark and also to enforce and proceed in infringement actions. So that does put a lot of people off, obviously, but it is financial benefit to it. That's why you see the bigger companies and corporations religiously use trademark procedure and trademark infringement procedure. It's costly, but they'll know they'll recoup the money, and it's worth enforcing.
Tell me something. We had a question from Wes Cole earlier on who was talking about coat of arms. Are you
Mm.
allowed to use that within a logo? How does that work?
So when it's an existing coat of arms belonging to someone else, you cannot use it in your logo. So you can't use the South African coat of arms um, or any other organization that's registered at the Heraldry Bureau. You can't use it in your logo. Um, you want to come up with your own coat of arms, it's more for heritage purposes, and then you approach the bureau. But you find it's a lot easier to just register a trademark if you can. Um, but you cannot use existing coat of arms in your logo. If you want to design your own coat of arms, you can follow that procedure. You can maybe design it in a way that it can receive trademark protection as well.
Okay. And when it comes to stock images that are either, well, they're on the internet, because I mean, the other day I came across someone who was just taking images of Google, for example, and I'm like, no, you can't just do that without. So just share with us what is the story with stock, because sometimes I think there's a lot of confusion with regards to images on the internet.
Yeah, you have to be very careful what is free to use images which you can take and use, and those which are not free and copyrighted. Because if you use those images which are not free without permission and without paying the royalty, you can expect a bill. Unfortunately, they are allowed to then enforce action, so you need to be careful. You need to check which is those free stock images and which you need to have to pay the license for or royalty fees for, because they can later on sue you for the use of the royalty. Um, and that's in all spheres, not just in business. Maybe for charity organization as well by accident take an image and use it without the consent of the copyright owner and can be sued. So it's very important and something that goes under the radar. So very good question. People just use images and they
I
can,
see.
yeah.
I have, and all this applies to audio and video as well. And I'm noticing now lately when you upload something to YouTube, it's first checking to see if there's any copyright
Yeah.
use of music, copyright use, I'm guessing, of sound, uh, what the content consists of. So I
Yeah,
guess the more we move into AI, this will become a factor, really.
yeah, there's a big debate now with this Jerusalem challenge. I don't know if you are in the news.
I saw something, but tell us about
Mm.
it.
Yeah, it's just basically that they need to start looking which businesses use the song to promote their businesses and not for recreational activities, and then sue for unfair use and without consent, without license,
Oh,
if they use it to
wow.
promote their businesses. Yeah.
Oh, goodness me. That is quite a big one because a lot of people were actually doing the Jerusalem.
It depends on
As
the context that they were using it. I mean, if they were using it innocently, then nothing will come of it. But obviously, if they use it,
But
um,
how does one yeah, but how does one distinguish whether it's fair usage or it was used innocently,
uh,
especially if a company decides to get up because, we're all doing the Jerusalem as part of, I don't know, part of the vibe, part of the exercise. I mean, maybe it could have been the staff member just woke up one day and said, "Hey, let's all do a Jerusalem in the store," and then everyone goes and does their things in a uniform, and now the company gets sued. I mean, that is quite a possibility.
yeah, no, it depends. Again, that sounds again innocent. If they use it to promote their business, like on behalf of one, the ads on their pages as well, to get themselves more exposure, and then you're treading a fine line. But I mean, if a staff member is just waking up, they still there's a recent challenge because everybody's doing it, and it's fun, then it's fine. There's no promotional use thereof. So yeah, so that is how you would distinguish whether you're using it fairly or whether you were actually infringing his copyright and whether you're due to pay him royalties. Yeah. So if I had to
Oh,
post,
wow.
yeah.
Okay,
So
that is interesting.
mm,
Sure, that is very important that we know about it. I mean, a few weeks ago, well, last year, actually, I got a letter from a lawyer to say that I was using some image on my site that, stock image. And I just know that I paid for it because I pay for all my images. You know what I mean? Whether I buy in bulk or whether I buy in short, I know I pay for it. But unfortunately, I do tend to store them on these kind of disk drives. And so now I'm going to have to go and hunt all this thing. But like I explained to the person, I said, okay, so you're accusing me of this, but please prove to me how I could have removed, because if you buy a stock image, they all are watermarked. You can't buy a stock image. I mean, all stock images have a watermark on it from the company. And so I turned around and said, because I mean, I didn't know where I bought, because it was years ago. I mean, this is 2010, somewhere around there, you know what I mean? And I would have definitely gone through loads of hard drives by then. And I remember one or two stock companies changing ownership over that course in time. And so I said, but how would have I been able to remove the watermark on the image if I'd not purchased it? You know what I mean? And then they
yeah.
came back to me, said, okay, no, well, fine, we'll let it go. Just remember, blah, blah, blah. And I'm like, yo, I do, because I must purchase the copy of the image, and there's definite watermarks on there. All right. So thank you, Desiree, for commenting. Very interesting. And let's see. We see that pathing. So Eve is asking, so is a trademark and a logo the same thing?
No, it's not. Trademarks are only used in the course of trade, badge of origin. A logo can be anything, any visual design. So what distinguishes a trademark from the rest is that it's actually used to distinguish your goods from others, and then it's used in the course of trade as well.
And normally there's a little TM
Yeah,
on every trademark single word that
yeah.
I've noticed.
You could say that the logo is a form of possible trademark. Yeah.
Okay. Okay. Yeah. But I guess the big takeaway from today's talk is really, guys, if you have a logo, thankfully I design my own logos, but if you have a logo, to get that permission, just get that in writing that you are the owner of that logo, especially if you're paying for a designer to do your logo, which many people do because not everybody has that creative flair. So I would say, 95% of businesses have logos designed by designers, so make sure that they are owned by you. Any last thoughts or words you want to share with our audience before we close off, Garth?
Yeah, we just again strongly recommend the registration of trademarks because of especially from a franchise point of view, so that you have something to license, you have something to sell. Maybe another Google one is worth billions. A big part of since this is a franchise association, big part of franchising is the trademarks, because then you have something to attach the license. If you don't have a registered trademark, and then it's obviously very difficult then to start a franchise business. So it's worth it, cost, and it's expensive, but it is worth it. And to have that peace of mind, that piece of paper, that you protected, and if somebody infringes that you can take action.
Absolutely. And you were just reminding me about brand equity, and that is the thing. When you start a business, especially when you're expanding and you start becoming a franchise business, now you're starting to grow brand equity. And part of that brand equity would be your trademark, would be your logo, would be your brand image, your brand culture. So it is kind of important. I mean, if when you grow, and what they mean by brand equity is that your business has a value in monetary terms, in terms of the assets that it holds, in terms of the business functionality, but then you add more value by having that look or that name attached to it that has a look and a feel. I mean, just Googling up here quickly, the brand value, because you mentioned Google, between 2006 and 2020, Google's brand value was relatively steady for 8 years until 2014. So the brand value saw a steep increase, with 2020 become the record year for the tech giant, and it's now worth I don't even know how to say that, 323.6 billion in value. That is Google's brand value. And the same goes for all these companies, Coke, Nike. If you start looking them up, they all have a brand value equity that is separate from the actual business brand equity. Right, so everyone, thank you for joining us today. Thank you for your comments. We really appreciate them. I see a lot of people have been tagging in names. So-and-so, you need to look at this. Yes, we all need to understand copyrights and trademarks, because I think, especially with the internet and the virtual world coming up into play, a lot of the artificial intelligence, the machines will be able to now pick out and distinct. So it's going to be harder just to be able to use someone's copyright, to use someone's brand. Now with blockchain coming into place, blockchain is I'm still trying to grasp the concept of blockchain, but you can pretty much do so much with blockchain. And one of them is, for example, artists. It's going to be difficult for people to copy other people's artwork, because if it's created within the blockchain or something, it's like a signature that it belongs to that artist. I'm still trying to wrap my head around that one. But yes. So thank you. So Desiree Parker says the franchisor owns the registered trademark, not the franchisee. That is correct. Is a jar. Just highlight that a little bit for us, Garth, before we close.
Yeah, the franchisor owns the trademark, and then he licenses it to the franchisees. So ownership doesn't change hands. It's still the one owner, the franchisor, and what you get is a license to use the mark and other stipulations based on the relationship. But you don't become the owner; you become a licensee. So you get to use the mark, in exchange for royalties. Yeah.
Okay.
Yeah.
Gotcha.
So,
Thank you. Thank you so much. Well, everyone, that's all we got time for today. Thank you for joining us, and join us every Tuesday to come and talk about franchising, business, and ideas and thoughts in general. So everybody, have a super week forward, whatever it is you're doing. Thank you for watching.
Thanks. Bye, everyone. Have a good week.
We will do, most certainly.